Live from the TV30 studio, here is Jim Schneider.
Good evening and welcome to inFocus. We're glad that you've joined us for the program tonight as we keep you informed on the issues that are happening within the state of Wisconsin. We're also going to be taking a look at a number of matters tonight that give us a rather full plate. Tonight we're going to be discussing in part the vacancy that's been created now on the United States Supreme Court since the passing of Ruth Bader Ginsburg this past Friday. We're also going to be discussing the special order that came out from a federal judge today, changing in part election law as passed by the state legislature. What did he decide, and what are the implications of that? Also, we're going to be taking a look at a couple of lawsuits that have been filed here in the state of Wisconsin, one of which challenges Governor Evers' second emergency declaration for the same emergency that he had a declaration for earlier this year. And tonight we'll discuss a lawsuit against Dane County for their school closure order. Joining us by Skype this evening, we welcome Rick Estenberg, founder, president, and general counsel of the Wisconsin Institute for Law and Liberty. Rick, so good to have you with us here this evening.
Thanks for having me on, Jim.
Rick, of course, much going on. As you know, there is a intense political battle going on right now due to the vacancy on the U.S. Supreme Court. Give us your overall perspective of what we see taking place.
Well, you know, I always like to pause at the outset. Someone passed away, and although I disagreed with Ruth Bader Ginsburg on the law, she was by all accounts a very nice person, a very competent person, a person who had a tremendous history as a litigator, and we can take a moment to mourn her loss and to express our sympathy for her family. That won't, unfortunately, last for very long because we're going to move quite quickly into the controversy about whether or not it's appropriate for the president to replace her this close to a presidential election. And I think some degree of controversy over if that's going to happen, and if he does move forward, and I think he is, who the nominee ought to be.
Mm-hmm. I have here Senator Ron Johnson's office sent just earlier this afternoon this information here regarding the fast facts on the Supreme Court. He said the president has nominated someone all 29 times the Supreme Court vacancy occurred during the final year of a president's term. 19 times the president and the Senate were the same party. 10 came before the election, of which 9 were confirmed. 9 were after the election, of which 8 were confirmed. There were also 10 that occurred when the president and the Senate were of different parties. 6 nominated before election, only 1 confirmed. 4 nominated in the lame duck session, only 1 confirmed. So the bottom line is of the same party, 17 of 19 confirmed in the election year. Different party, 2 of 10 confirmed. 70% of justices confirmed since 1900 confirmed in under 46 days. Ruth Bader Ginsburg, 42 days. Sandra Day O'Connor, 33 days. John Roberts, 23 days. John Paul Stevens, 19 days. Some interesting statistics there.
Right. So we should think of this in terms of the law and the norms, because a lot of times we have norms, we have rules that we try to live by, and they're not strictly legally required, but they're things that we should try to live by. In terms of the law, it's very simple. The president has the duty to nominate someone to fill the vacancy, and the Senate has the ability to advise and consent, and the person will not assume a position on the court unless the Senate does consent. The Senate has no obligation to approve of the person that the president has nominated. It may reject that person. It may reject that person for any reason. It has no obligation to hold a hearing. In fact, we never had hearings in the past. People were nominated for the Supreme Court, and the Senate would approve the nomination, and there never would be a hearing. And the Senate has no obligation to vote if, in fact, holding a vote would be an empty gesture. In the case of Merrick Garland, as you point out, the president and this was a Democrat. The Senate was controlled by the Republicans, and there was an interbranch conflict. The president, President Obama, exercising his responsibilities, believed that Merrick Garland should sit on the United States Supreme Court. The Senate, exercising its constitutional responsibilities, disagreed. It did not believe that Merrick Garland should sit on the court, and it chose not to consent to his placement on the court. And that was within its constitutional prerogative as well. And as Senator Johnson's numbers point out, that's not inconsistent with the norms. Most of the time when there is an interbranch conflict between the executive branch and the Senate in the year of a presidential election, the person who is nominated to serve on the court does not get approved by the Senate. It's a different matter if the president and the Senate are controlled by the same parties. The president, once again, and President Trump, when he nominates someone on Friday or Saturday, will be doing, as Senator Johnson pointed out, the same thing that has happened 29 times before. Every president before him was faced with this situation, nominated a replacement, and the Senate will then exercise its constitutional responsibility, and if it agrees, the majority of senators agree that, yes, this is the right person to serve on the United States Supreme Court. If they believe that, then I think they have a constitutional duty to approve the Senate, in that instance, to approve the president's nomination, right? If there is a difference between what happened with Merrick Garland and what will happen here, it's that in 2016, a majority of senators did not want Merrick Garland.
Right.
If it turns out differently here, it will be because a majority of senators do want whomever it is that President Trump nominates.
And just looking back 4 years ago, Newsmax.com put out the story here today as well that Ruth Bader Ginsburg actually supported Merrick Garland 4 years ago, and she said this because it was asked about whether or not they should confirm an election year. She said that's their job. There's nothing in the Constitution that says the president stops being president in his last year.
No, right. And the senators do not stop being senators. And so they have the right to form their own independent judgment as to whether or not a nominee should be confirmed. And, in the case of the Senate in 2016, Merrick Garland did not have the votes, and no purpose would have been served by holding a hearing or taking a vote to reach what would have been a preordained conclusion. He didn't have the votes to be approved, and in this instance, we'll see whether or not the person that is nominated by President Trump, has the 50 votes that it will take to be approved. I say 50 votes because presumably if the senators split 50-50, then Vice President Pence would cast the deciding vote, and I can't imagine that he would not vote to confirm the president's nominee.
Just one last issue on this topic here. I've got a copy of the Milwaukee Journal-Sentinel here, and here's a headline from yesterday. Johnson backs filling court vacancy despite stand against it in 2016. Now, he did take a stand against that in 2016, but what they could have had as a headline is about Tammy Baldwin is flipped on this issue here then as well, because here is her press release from March 16th of 2016 about Tammy Baldwin's statement of President Obama's nomination. I'm pleased that the president has done his job, offered a nominee in the spirit of bipartisanship and cooperation, and I encourage my Republican colleagues to give Judge Garland fair consideration. To ignore this nomination is wrong and irresponsible. Senate Republicans need to do their job and provide Judge Garland a hearing and an up or down vote. I believe the American people deserve to have a full and functioning Supreme Court working for them. Now, when it comes to September 19th of 2020, she said the election that will determine our next president and control of the Senate is only 45 days away. Voters across America should be allowed to cast their ballots first before Supreme Court nomination and confirmation process moves forward. So we could have seen that headline mention Tammy Baldwin in that same regard.
It's like we have a hypocrisy sweepstakes here.
Yeah.
And the reality of it is there's no rule that you must take a vote, and there's no rule that you may not take a vote.
Right.
In each case, I think Justice Ginsburg had it right here. A president doesn't stop being president and the senators don't stop being senators. And so they have been elected to fulfill their responsibilities. They hold that position until the end of the year. President Trump will nominate who he believes would be the best justice, and the senators will have to decide whether they agree with him or not. And if they do agree with him, that person ought to be confirmed, because that will be a product of both the president and the senators doing their jobs. They did their job in 2016. They didn't ignore Merrick Garland. They simply did not approve him.
Rick Essenberg, our guest here tonight on inFocus. Today, a decision coming out from a federal judge pertaining to our elections, and which they kind of moved the bar in what the legislature has set. Some decisions that impact when voters can return ballots, that they're saying now that it doesn't have to be election day, that the election the clerks have to receive the ballots. Rather, they have to mail them by election day, and they'll have a period of number of days, up to 6 days afterwards, to receive the ballots. That's a changing dynamic here for the state.
Right, and I think, you know, I have a great deal of respect for Judge Conley, but I'm afraid he's micromanaging the process here. If we're going to have an election, we have to have a set of rules. If we're going to have voter registration, right, there has to be a process by which you get registered. If we're going to have an election, there has to be a date on which it is over. If we're going to have absentee ballots, there's got to be a deadline for requesting them, and there has to be a deadline for them to come in. And the legislature has set deadlines in each of these cases. And it's very, very difficult to come to the conclusion that the district judge here is doing anything other than just saying, you know what, I really think the legislature should have given them a little more time. The legislature should have given another week to allow for registration. The legislature should have allowed more time for the ballots to come in. And that seems to me to be a very prudential judgment, the type that we normally expect legislators and not judges to make. And it will be interesting to see how the appellate courts react to this. And one of the things that they will come up is the very same thing that came up in the wake of the decisions that affected the April election, where one of the things that the United States Supreme Court pointed out is that it's unfair to change the rules of the game once the game has started. And so quite apart from whether or not a judge should be intervening, we're at a situation now where balloting has started, right? It is election season. The game is on. And to change the rules of the game in the middle of the game is something that federal courts have been traditionally reluctant to do. And so I think that there is no certainty at all that this decision will survive appeal. I think that the appellate challenge will be very strong. And
just in follow-up to that, I mean, here he's saying, okay, it must be postmarked by election day, 6 days to make it to the election commission or the clerk's office in this regard. But isn't this going to open the door for further matters of voter contention, in that not every ballot sometimes has a postmark on it? And so there are going to be ballots that will come, perhaps even entered into the mail system after Election Day, that could change the outcome of an election that doesn't have that postmark, and then that throws into controversy. Well, shouldn't every vote count? And I can see the lawsuits happening back and forth.
Right, and the odd thing about this is that how long, Jim, have we been talking about the potential for chaos on Election Day, with absentee ballots coming in after the day of the election? And it seems to me that if we've known enough about this problem to be debating it incessantly now for a matter of months, then it doesn't seem to me unreasonable to expect that people will get in their absentee ballot requests, and that they will fill them out, and that they will send their ballots in time to ensure that they will be counted. I mean, I've got I've got news for everyone. The COVID pandemic is not going away, right? People will still be getting COVID in November of this year.
Right.
if that is a concern for you, if you don't want to go to a polling place, I understand that, but then request your absentee ballot and make sure that it gets returned in time. Now, Judge Connolly says, well, you can't expect undecided voters to cast a ballot, too early, and there's some truth to that. In that, there is a fairly substantial argument that we probably shouldn't even have early voting at all. That election day should become on election day, and we should, ensure that people can get to the polls. But that, this one way to look at an election is this is the day of decision, and people should wait until the end of the campaign before they decide.
Right.
But we don't do that. We're letting people vote already, and so I think the notion that people can't get their ballots in earlier in light of all of the other things we do to encourage early voting is not particularly persuasive.
Rick, I'd like to advance to a couple of issues that caused us to invite you here on inFocus, and these things have happened since that time. But your organization, the Wisconsin Institute for Law and Liberty, is involved in a couple of several legal matters, two of which we're going to focus on this evening. We're going to focus, first of all, on Dane County and the school closure issue. Tell us what's happening. What is the basis for the lawsuit that was filed against Dane County?
Right. So when we're discussing these lawsuits, I think it's very important to start to understand that the premise for both of them, the beginning, is that whatever COVID restrictions we might choose to have, and whether we think the restrictions themselves are constitutional or not constitutional, they have to be adopted in a way which is in accord with the rule of law. And that was the principle that underlied the Palm decision, which was decided last May. Right? You'll remember that the legislature brought a lawsuit when the governor attempted to extend the Safer at Home order. His emergency powers were expiring. He needed some source of authority, so he relied on a different part of the statutes, which gives the Department of Health Services the power to take certain steps to control infectious disease. Now, the problem with that is that the Safer at Home order went further than that statute should be read to permit, and that statute required, the legislature argued, and we supported that argument at will and filed an amicus brief on behalf of some small businesses, that the governor proceed by rulemaking. With the Secretary of Department of Health Services, the governor's direction, proceed by rulemaking. Now, when you proceed by rulemaking, you have to point to some existing authority in the law. You have to have public notice. You have to tell the public what this is the rule we're going to make. You have to give the public an opportunity to comment on it. You have to take their comments into consideration. And the legislature has the ability to block the rule through a joint committee of the legislature called JCRAR. In other words, other people get to participate. You, as governor, cannot act unilaterally. The Palm decision agreed that the governor does have to proceed in this way. It didn't say that he can adopt or can't adopt certain restrictions. It said whatever restrictions he adopts, they have to be done in accordance with the rule of law. And so after the Palm decision in May, the Safer at Home order, the stay-at-home order, the lockdown, whatever you want to call it, it was done. And if the governor wanted to extend it, he needed to proceed by rulemaking. He started to do that, and then he abandoned the process, saying, well, he didn't think the Republicans would agree with him and do what he wanted them to do. And so nothing happened for a long period of time until we got the declaration of a new emergency order, and we got some local actions. Now, I think you wanted to start with the Dane County case, is that right?
Yes, let's do that.
So in the Dane County case, the question is, what can a local health department do to close businesses or to close schools? And one of the interesting things that you'll find if you look at the statutes is that when the statute describes what the Department of Health Services can do, it does talk about closing schools. When the statutes talk about what local departments of health can do, it does not talk about closing schools. Now, typically this difference would be regarded by lawyers as important that if in one set of circumstances you name the power and in another set of circumstances you do not include the power, then the inference to be drawn is that local departments of health do not have that power. So what happened in Dane County is the Dane County Public Health Department decided that it would, public schools would be closed, and public school districts can do that if they want to, but that the Dane County Health Department would then order private schools to be closed. And it would do it under this section of the law which does not explicitly give them that authority. And so the argument that was made in the case that we brought against the Dane County public health officials was that you have no power to do this. You cannot order private schools to close. Now, there are more arguments involved. All of these private schools, the ones that we represent and the ones that some other lawyers represent in this case, are religious schools. And so you have an additional problem. In addition to the absence of authority in the law to close the schools, you have the concern that for these religious schools, it may well be that having in-person instruction is part and parcel of their religious exercise. Think of a school that has chapel in the morning, right? Think of a Catholic school where, children attend Mass in the morning and they participate in communion. It's necessary for them to be there in person. And so there's a second argument, and the argument is that when the Dane County Health Department extends the shutdown order to religious schools, it is interfering with their free exercise of religion. And it cannot do that unless it has a compelling interest. And in this instance, given the fact that so many other things are open in Dane County, there is no compelling interest to do that. There are other arguments in the case. One argument is that by doing this, the Dane County Public Health Department is interfering in the right of parents and families to direct the upbringing and education of their children. I mean, whether or not there's a religious basis to that or not, and that this is a constitutionally protective prerogative, a right of these parents and families. And so what happened is Dane County decided, I believe on August 22nd, that it was going to order these private schools not to open. It doesn't matter if they have social distancing, if they have masks, if they have plexiglass, it doesn't matter. They could not open for in-person instruction. And many of these schools were set to open. They announced this late on a Friday afternoon. Some of them were set to open the following Monday. Many others were set to open a week from that following Monday. And so, we had to move very quickly to put together a group of parents, religious schools, some organizations, Wisconsin Council for Religious and Independent Schools, WCRIS, and School Choice Wisconsin, and we brought an original action in the Wisconsin Supreme Court. What that means is that we didn't go to the lower court. We didn't go to circuit court. We went directly to the Wisconsin Supreme Court, which is something that can be done in extraordinary circumstances where a case has great public importance, where there doesn't need to be a trial, because the Wisconsin Supreme Court is not a trial court. It doesn't call witnesses. There are some processes that you can use to do something quite similar, but the court generally doesn't like to do that. And that it's very important that the matter be decided by the highest court in the state promptly. The Wisconsin Supreme Court agreed to accept our case, and the case filed by two other groups of plaintiffs. The court doesn't often do that. It takes about 10% of the original action petitions, but in this case it did. And the matter is now pending there before the Wisconsin Supreme Court. The lawyers are in the process of filing briefs. In the meantime, the court issued what's called a temporary injunction. It's a temporary order. Sometimes we call it a preliminary injunction, which forbids the Dane County Health Department from closing these private schools. So right now in Dane County, these private schools are open for in-person instruction if they wish to be, right? They don't have to be. It's really up to them. And, most of them have various social distancing requirements and rules, and some of them have a combination of virtual instruction and in-person instruction. Some of them, have an option for families. If the family doesn't feel comfortable having the child in school, then, they can participate by Zoom or however it is they do it. But the point is that the law does not permit the Dane County Public Health Department to close these schools. And closing these schools in this context violates the religious free exercise of the parents and family and the right of the parents to direct the education and upbringing of their children.
And at the same time, I believe preschools are operating, are they not, in Dane County?
Sure. A lot of times what you'll see across the state right now is that schools will close for in-person instruction, but at the same time, they will offer what is essentially daycare or day camp options for parents who need some place to put their children. So what will happen is that you'll have the same children coming to the school who would have come there for instruction, but are now coming there basically to be warehoused because, their parents got a problem. Their parents got, have to go to work, and they need some place to have the child cared for and supervised.
Okay, so you can come here for supervision. We just cannot give you the instruction while you're here.
Yeah.
Okay.
There was a meeting at which one leader of a Milwaukee school, who I won't name, apparently got up and said, "Look, what if I do this? We'll close for in-person instruction, but we'll be open for daycare, and the daycare workers will be these people that we used to call teachers, and the daycare will consist of what we used to call instruction. Can we do that? Right? Would that be okay?" And so sometimes it does seem very anomalous.
Rick Essenberg is with us here tonight on inFocus as we talk about some of these pressing issues going on. And you went right to the Supreme Court. Has the Supreme Court set a date that they're actually going to be hearing this?
Yes, and I don't hold me to it. It's early December. I believe it's December 8th.
So and that injunction is in force until that hearing takes place then?
That's right. The injunction, now that's right, it's December 8th. The Dane County has moved to set aside the injunction, making some, they're not really making different arguments, but they're saying that there's an authority out there that they forgot to cite the first time around, and that type of thing typically doesn't work. So unless the court decides to overturn its injunction, what will happen is that throughout the fall, these schools will be free to be open, unless maybe we're anticipating the next topic, unless the governor acts in some way to impose his own school closing or other restrictive order here.
Yeah, and that's what we're going to segue into this point. I've got before me Executive Order number 82, and again, this is relating to declaring a declaration of a public health emergency in the state of Wisconsin, coming forth by the governor. And then on the heels of that, we also have Emergency Order number 1 related to preventing the spread of COVID-19 by requiring face coverings in certain situations. We're certainly not going to go through this line by line, but what we have here, Rick, in essence, is the governor declaring an emergency for a second time over the same emergency. You filed action against that.
You're right. So think of how we started this conversation, where I said the point is not so much the nature of the restrictions, it's whether or not the governor has the authority to proceed in the way that he's proceeding. So back in March, and the statutes say that the governor can declare an emergency. The public health emergency is one type of an emergency. A disaster emergency is another type of an emergency. An emergency can be many, many things. It's very broadly defined in the statute. In this case, he declared a public health emergency, which is also broadly defined. And he declared that in early March. State law that, and when he has declared an emergency, he has very broad authority to act. He can enter any order necessary to protect person or property. I mean, he can essentially rule by decree. Obviously he has to respect things like freedom of speech, free exercise of religion, public assembly, that type of thing. But all the normal processes that we have to make law, where you go to the legislature and you get something passed by both houses and it's signed into law by the governor, these things are not necessary for him to enter these orders. So it's in a very extraordinary time when the governor has declared an emergency. It gives him exceptional power. So in recognition of that, our law says that the emergency may only last for 60 days. Now, remember, what the law is not saying is that emergency conditions will go away after 60 days, right? They're not saying that the pandemic must go away after 60 days. Right. What they're saying is that this extraordinary legal state in which the governor can basically rule by decree, that public health emergency that permits him to have those powers, that can only last for 60 days. It can be rescinded at any time by a joint resolution of the legislature, and it can be extended, but only by a joint resolution of the legislature and only for an additional 60 days. So clearly, what the idea here is that the legislature said, look, there are circumstances in which the governor may need to act promptly, and we don't have time to have the legislature act because there's some kind of emergency, exigent circumstances. We've got to give him a little leeway in order to address that. 60 days is enough time. That's the judgment that the legislature made. And after that, we have to return to regular constitutional order. And so what happened here is the governor declared the emergency as it approached early May when the 60 days was about to expire. As I noted earlier, he attempted to extend his safer at home order by using another provision of the statutes. The Wisconsin Supreme Court in the Palm case said that he could not do that, that he had to proceed by rulemaking. He gave up that process, and so there were no statewide, it's not quite true to say that there were no statewide restrictions, but there were no general statewide restrictions. That they had to be sort of based upon some other authority, and they were sort of limited in scope. And so as we got towards the end of July, what the governor did is he decided to declare a second public health emergency. But nothing had changed, right? The number of COVID cases, COVID had never gone away between May and July. We all know that. The number of cases was comparable to the number of cases that we were having at the time of the Palm decision in mid-May. What the governor had simply done is he had decided to help himself to an additional 60 days by declaring a second emergency in series arising from the same underlying facts, as you rather succinctly put it when we began this conversation. Now, the legislature would have had the ability to rescind that emergency at any time, and Senate Majority Leader Fitzgerald said that he was willing to take that vote and do it, for reasons that you'd have to ask him about. The Speaker of the Assembly did not commit that body to taking that course of action, and so as a result, we filed a lawsuit in Polk County challenging the declaration of the second emergency. Now, what had happened? The governor declared the second emergency, and then he imposed a statewide mask mandate. Right. And so our clients, they live in Polk County. The level of COVID infection in Polk County, which is in the northwestern part of the state, is very, very low. They've averaged about one case a day since this began. And, whatever you may think of the need for a mask mandate or the importance of wearing masks in Milwaukee County or Ozaukee County, where I am, it's hard to make a case that it's really necessary in Polk County, Wisconsin. Yeah. And so we have challenged the declaration of an emergency. The case is pending. We're having some trouble getting a judge assigned because the judges have all recused themselves up there. And the question now before us is, what will the governor do with this second public health emergency? It is set to expire on September 28th. That's a week from today. Will he extend it for another 60 days? I mean, if he does that, I think the transgression of the statutes is so obvious. You know, he's just helping himself to something that the law does not give him. Will he do that? Will he do that in order to extend the mask mandate? If he does it, will he impose some other form of restriction, including, possibly a renewed safer at home order, citing the fact that, we have a higher number of COVID infections now than we did, a while back.
And at the same time, we have just a push for massive testing taking place, even though there's a lot going on. But when we take a look at this particular emergency declaration, knowing that he already is calling for a second emergency over that first initial emergency, could he not even just wait a week and just declare another emergency to go in for 60 days using his same rationale? I mean, it seems like it's unlimited power that the legislature never intended for him.
That's right. I mean, it basically creates the specter of the governor declaring a more or less permanent emergency. And given the breadth of the definition of an emergency in the statutes, we should be concerned about that. Mm-hmm. Here we're dealing with COVID, but an emergency could be anything. It could be climate change. It could be racism. It could be, illegal immigration, right? It could be almost anything. And so the point is that there has to be a limit on the governor's ability to do this. And the statute, I think, has placed that limit by saying that, look, you can't do this for more than 60 days, and if the legislature wants to give you another 60 days, that's fine, you can have that, but that's it. You don't get any more than that. And if, in fact, the statute were to be read to give him power to declare an indefinite emergency and rule by decree, I would argue that it's unconstitutional. I would argue that it's a violation of the principle of separation of powers because it allows the governor at that point to legislate. And if you look at our Constitution, the power to legislate is reserved to the legislature. It is not placed in the hands of the governor.
Now, Rick, you filed this in Polk County and still waiting for this hearing to take place. Is there a point in time when you say, hey, this really needs to go directly to the Wisconsin Supreme Court, as you're doing in the education case?
Yeah, I mean, that could happen. I think in this case, we felt it better to file it in the lower court. I mean, that is the normal way that this thing happens. Mm-hmm. And, if there could be a point at which we seek a preliminary or a temporary injunction in the Polk County case, and if that's denied or granted, that decision can be appealed, and that by that vehicle, the case can through a process called bypass. It can go directly to the Wisconsin Supreme Court if that is deemed to be the best way to proceed.
So if Polk County advances here, whatever happens for Polk County, that would have an impact for the entire state, not just Polk County?
Sure. Well, yeah. I mean, we always have this argument about federal courts and whether they have nationwide injunctions, and we had this issue in Act 10 where Dane County Court had held that Act 10 was unconstitutional, and the question was what impact would that have? But ultimately, by time it gets up and it becomes a decision that would be made by a higher court, particularly the Wisconsin Supreme Court, then it would be a case that would have precedential value, and it would be something that would be resolve the issue across the state. And so, because there isn't anything special about Polk County in this case.
Yeah.
I mean, we're saying the governor can't declare a second emergency. We're not even, although our clients certainly believe that declaring a mask mandate in Polk County is unreasonable, that's not what the case is about. The case is not about whether you should have a mask mandate or not have a mask mandate. There are other ways that the governor could pursue a mask mandate if he wanted to. Again, he could use rulemaking. He could go to the legislature. The issue here in this case is, can he declare a second public health emergency? And we should not want that.
Yeah.
I mean, we do not want to give a single person that type of power. And for people who like what Governor Evers has done, and they like Governor Evers, that's fine. But they have to keep in mind that someday there will be a governor that they don't like, right? Scott Walker was governor. They probably didn't like him. Did they want Scott Walker to have that type of power? You know, we should not get too focused and too obsessed about the particular things that the governor has done, because we need to have the rules right.
Yeah.
And we can't give this type of overweening authority to a single person.
Rick Essenberg with us, and ladies and gentlemen, there is something called the rule of law, and that's what he's talking about here, the rule of law, and we need to follow the laws. There's a system in place. We can move forward here with the rulemaking, have the legislature convened to extend things an extra 60 days. So there's a process that has been put in place for that. Are we violating that, though? And that's the essence, certainly, of that suit, to have this rule of law. We're going to open our phone lines tonight and take your questions. Before we do that, though, let me just give you a point of contact for our guest. It's the Wisconsin Institute for Law and Liberty, and their website is will-law.org, will-law.org. You see their email as well, info@will-law.org, and their phone number at 414-727-WILL. That's 414-727-9455. Tonight we'd like to take your questions, a brief comment. We've had several points of discussion here tonight pertaining to the vacancy in the United States Supreme Court, to also talking about the extension that a federal judge has given for the absentee ballots to come in on after Election Day, but postmarked by Election Day. We're also talking about the lawsuit against Dane County as far as the restrictions placed upon schools, and primarily they're focused even on religious schools and its implication. And then also the extra emergency that's been declared by Governor Tony Evers over the very same emergency that he invoked earlier this year. And does he have the constitutional authority to make a second declaration regarding the first? Our phone number, 414-935-3030, 414-935-3030. Toll free, you can reach us at 800-733-8830. That's 1-800-733-8830. If you'd like to text in your question tonight, you can text a question. Again, this number is only for text. Send it to 414-439-3585. That's 414-439-3585 with your text in questions. So that's a way to reach us. Again, one more time on the text, 414-439-3585. To call in online with us here tonight, 414-935-3030. That's the call-in number, 414-935-3030, or toll free at 800-733-8830. Critical issues here in the state. Let's go to Yvonne calling in from Milwaukee. Hi, Yvonne. You're on the air.
Yes, I would just like to make a comment as it pertains to the Supreme Court justice. Now, the Republicans, many of them gave their word and said that if Donald Trump had a chance to select another Supreme Court justice, that they would wait until a new president was elected. And so we're talking about a matter of your word. Your word is supposed to be your bond. And what you say, you're supposed to uphold to that. And so that's my concern. And I know about the law and this and that, what all you're saying, but my point is your word is your bond. You said that you were going to wait until the election came the last when Mayor Garland,
Okay.
you didn't even give a hearing.
Okay, got your point there, Yvonne. Thank you for the call. Any response to that, Will? Rick?
Yeah, well, yeah, I can understand why the caller would feel that way. Now, I don't think that there are many Republicans who actually went so far as to say that, but I think she may be referring to Lindsey Graham, who at least came very, very close to saying that. I think he ought not to have said it. I think he ought to have been more careful with the way that he expressed itself, because, there's another side to this. And the other side to this is that this isn't just somebody acting in their personal capacity, Lindsey Graham or Mitch McConnell or whoever, acting as individual people. They are acting as United States senators, and they have certain obligations. And, when we argued at the outset that when President Obama nominated Merrick Garland, that the Senate had an obligation to take that nomination seriously and not ignore it. Well, I would argue they didn't ignore it. They knew who Merrick Garland was. They didn't want to approve him. They chose not to do it. He never had the votes. Mm-hmm. So they exercised their constitutional responsibility in that way. Here, Lindsey Graham still has to exercise his constitutional responsibility, and he may have expressed himself poorly, but he's still a United States Senator, and he's got a duty, and his duty is to take whatever President Trump does and exercise his responsibility with respect to that. And I don't think he can simply rely on the fact that I said I wasn't going to do my job, so now I'm not going to do my job. I think that would be a mistake.
And thank you for the call. 414-935-3030 is the number, or 800-733-8830. Again, you can text in your questions here as well tonight at 414-439-3585. We're going next to Tom in Heartland. Tom, you're on the air.
I don't know why when you hear of an overreach by a health department, or in this case the governor, mm-hmm. and there's a court ruling against him, why is there no fine? Why is there no comeuppance? They're not fined, they're not removed from office, they just go on to the next barricade, it seems like to me. Mm-hmm. There's no consequence to it, even though they've overreached.
Okay, thank you for that. So he's saying here, Rick, that the governor has overreached in doing this. Why are there no consequences? In that we've already seen in the Palm case, the court say, hey, your declaration lasts for 60 days only.
Well, in the Palm case didn't actually reach the governor's emergency powers. That was a different section of the statute. So, in fairness, it did not make that particular ruling. But I think what happens here is that public officials take certain positions upon what they think that the law requires, and very often, you got lawyers on both sides who can, defend conflicting positions. And so typically what will happen is that if a colorable argument can be made that the public official has tried to follow the law, then what happens is they get told to act right. So in this case, Governor Evers, if we were to be successful in the Polk County case, he would be told, look, you can't have a second public health emergency. Now, sometimes there is a provision for the award of damages against persons. Sometimes there is provision for awarded damages against the public official himself or herself, and we're having a big debate on that in the context of police shootings, whether we should have something called qualified immunity, which explaining that would go way beyond the scope of what we're talking about here. But in this case, I think the issues will be what is required to conform to the law, what is permitted, and the remedy will be fixing the situation. The remedy probably will not involve any kind of sanction against anybody, at least as long as they, once they are ordered to do something differently, they comply with that. If they don't comply with it, then that would be another matter.
Okay, let's 414-935-3030 is our telephone number. Kirk is calling from Oak Creek. Hi, Kirk, you're on the air.
Hi. With the mail-in ballot being accepted, postmarked by November 3rd, when do you predict the final count to be? 3, 4, or 5 days later, or what would you suspect?
Thank you. And I believe, Rick, that actually the judge has given for 6 days for the ballots to come in.
Right, 6 days for the ballot that is postmarked on November 3rd to come in, and so we know by minimum that you're not going to get a final count until November 10th. And if you're going to have a lot of absentee voting, and you're going to have a lot of late absentee voting, then you're not going to know who won if it's close.
And are we the only state
not so close.
November 3rd mail-in ballot?
Sorry?
So he's asking, are we the only state where there is allowing for this to take place?
There's litigation like this around the country, and so and there are some states where this is permitted. So California is notorious for this, where if you look at the vote totals on election night, it looks like a particular party has won. Right, in 2018, it looked like a number of Republican congressmen had won their election in the midterms, and a week later we found that they didn't, because ballots that came in late flipped the election. And so we're not the only state, but it's going to be particularly important here because Wisconsin is a swing state, and at least at this point, it looks like the election in Wisconsin for president is going to be pretty close.
Yeah. Thank you, Kirk.
Thank you.
Appreciate your call here tonight. 414-935-3030, the number, 800-733-8830, or you may text in your question tonight to 414-439-3585. One of the things that we're seeing with this, Rick, is the possibility that there could be, it's like we're creating scenarios for turmoil to take place by changing, in the, bottom of the 8th inning or start of the 9th inning, starting to change election rules, and whereby our legislature has already drafted things. They've worked really well for our state for a number of years, and then when we start meddling, it's similar to the spring election, where the governor said, no, I don't have the authority to stop the election, but then tried to stop the election from taking place. And all of these actions, though that was found to be unconstitutional, throws the whole voter matter into great turmoil in the state.
That's right, and the problem here is that our election in April was a bit of a mess. But I'd say it was only a bit of a mess, right? I mean, I think the governor made a fundamental mistake when he tried to call off the election at the last minute. I mean, he was going to get his hand slapped doing that, and he did in record-breaking time. But all things considered, we had an election where, when we started the early voting period, people, COVID was not something that was of particular concern to anyone. And by the time that we ended the election period and we got to election day, the state was locked down. And so in light of that, I actually think that municipal clerks and the election commission and they handled things pretty well. Not perfectly, but pretty well. Now, there were some bad things that happened. Green Bay, I think, had 1 polling place. The city of Milwaukee had 5 polling places. There was no excuse for that. They should have been able to do better than that. But now, given the fact that we have had, we're going to have had 7 months to get ready for this, and we've known for every one of those 7 months that, these particular situations are going to present themselves. More people are going to vote for mail. In 2016, about 26% of Wisconsin residents voted absentee. In the April 2020 election, it was over 70% that voted absentee, and mostly by mail. you can vote absentee in Wisconsin. You don't have to have a reason, and there are going to be a high number of ballots that are cast by mail in the fall. That's simply going to happen. Nobody can prevent that.
Rick, we've got just a couple minutes left, and here's another texting question. It says, my question is, what's going to happen with the schools and all the teachers taking off of work? How will kids learn what they need to know? And we know that there's a lot of things happening with the virtual education and so forth, and some kids have a hard time adjusting to that and following that. Is there concern for this generation coming up through this education system in such disarray?
I think there's incredible concern. I mean, there can be a place for virtual learning. But, ironically, sometimes the kids that are going to suffer the most are the ones who, maybe they don't have the best internet at home. Maybe they don't have a situation where their parents are in a position to supervise them, during the school day. Perhaps they have to be at work. And so, ironically, by going to this virtual instruction, it's going to be the kids who are struggling the most, who are hurt the most. And so, I'm all for being reasonable about, COVID. It's a serious situation. But we also have to take into account, as you put it, the next generation, who basically lost a semester of learning in the spring of this year, and we don't want that situation to continue. And so we have to take into account, what's good for kids as we sort through this. And I think that to simply say that we can't have any virtual or we can't have any in-person instruction under any set of circumstances because of a relatively small risk, one that doesn't really seem to have much impact on kids. I mean, I know two people, Jim, who have tested positive for COVID. They're two of my grandsons, and neither one of them got very sick. It's just something which thankfully doesn't affect young people as much as it does. Yeah. Yes, you should have a way to protect older teachers, but that's what we should be focusing on.
Rick, thank you very much for being with us here tonight on inFocus and for your work that you're doing and certainly acting on behalf of the public in so many ways.
Well, thank you very much, Jim, and thank you for letting me speak to your viewers tonight.
And Critical Issues, friends, again, Rick Essenberg with us tonight from Will. If you'd like to contact their organization and find out more about them, you'll find it on their website at will-law.org, will-law.org. Email address, info@will-law.org. And the phone number is 414-727-9455. That's 414-727-9455. And they'll help you out best way that they can answer your questions. Lord willing, next week, Pastor Sam Jones from Families in Focus scheduled to be with us talking about many of the issues that are impacting us in the city. We trust you'll join us. Thanks for joining us tonight on inFocus. Good night.